Hey y'all, Erica Libran here, Blair Cato's title attorney with a new series for lenders called Title Tips Tuesday, in which we discuss issues that routinely come up in title and how we can work together to avoid delays associated with these issues. So the very first thing that we're going to talk about for Title Tips Tuesday is trusts. How's that for alliteration? So trusts often come up where you have a buyer-borrower who is either purchasing property and they want to put the property in the name of a trust, and they're going to mortgage it in the name of the trust as well, or you have a buyer-borrower or a borrower who is refinancing property and they currently hold property in the name of a trust. So the first thing that you need to know is that in South Carolina, trusts themselves cannot hold title. So the trustee of the trust is who the mortgagor needs to be, and that needs to be the same person who is holding title. So it should read John Doe as trustee of the John Doe Revocable Living Trust, dated whatever it is. Second is you need to know what we need to know. The very first thing that we need when we see that a trust is either going to be taking title or is currently on title is we need to be able to review the trust agreement. The reason for that is that we need to review that we have the proper trustee, the proper name of the trust, that the trust was set up properly, and most importantly, that the trustee has the authority to buy, sell, or mortgage the trust property. Mortgage is a big key. We want to make sure that they do in fact have the authority to sign that mortgage. Third thing is once we've confirmed everything and we've got everything set up the way it needs to be set up, we need to have a certification of trust or a memorandum of trust recorded at the same time as the mortgage or the deed. What that means is we need to have a document that is recordable in South Carolina in which the trustee signs confirming that they are in fact the correct trustee, that they have the authority to sign the mortgage or have the authority to mortgage the property, and the correct name of the type of the trust itself. Like I said, this has to be a recordable form. That means 2 witnesses and a notary. We will record that, and that is a $10 flat fee recording charge in South Carolina per trust certification. If your buyer borrower does not have a trust certification or memorandum of trust already prepared, we can prepare that form, but it will be an additional cost, and that's something that you need to know so that you can pass that along to your buyer borrowers. It is often in the range of about $150 to $350 depending on who your buyer borrower has retained as their closing attorney. So that's about it, what you need to know quick and dirty about trusts. If you have any additional questions or concerns specifically about trusts or any other title issues that often come up in your real estate transactions, please do not hesitate to give me a call. My telephone number is 803-881-6904, and my email address is Erica, ERICA, at blaircato.com. I look forward to hearing from you. I hope that I have giving you some good information here. And if I have, please forward it over to your other lender contacts, lender friends. And like I said, please feel free to reach out to me should you have any questions or other topics that you'd like for me to address. I hope you have a great start to your 2021 and have a great rest of your week. Thanks.